Are you thinking of transferring or hiding money before divorce? You could be committing financial fraud even without realizing it. Divorces can get messy, guys, and when businesses are involved, things can get even trickier. But what if your spouse is secretly draining assets or deflating business value? Can my spouse hide money before the divorce? These are questions you might ask. Can they transfer assets to keep me from getting my fair share? Today, we're breaking down the warning signs of financial fraud in divorce, how assets are hidden, and what you can do to protect yourself. Make sure you stick around, because at the end, I will be talking about how courts handle marital waste when one spouse is recklessly spending or transferring money before or during a divorce. Welcome back to the channel, everyone. I'm attorney Kyle Kaufman, hkklaw.offices.com. Let's talk about marital waste. This is when one spouse burns through money. Marital waste is when a spouse is recklessly spending or transferring money before or during the divorce to reduce what the other spouse can get in the asset division. And you might be wondering, can I recover my money my spouse spent irresponsibly before or during our divorce? How can I stop my spouse from draining our accounts before the divorce is finalized? Wisconsin law does have provisions to address these questions. Wisconsin statute section 767.117 sub 1b and statute section 767.63 can help you. Both of these statutes are designed to prevent the reckless transfer of marital assets. And here's how they work. Let's talk about spending during the marriage. This is prior to filing. How can I recover my money negligently spent by my spouse during the marriage is what you should be asking. If you're someone and your spouse blew through more than $500 within 1 year before the divorce was filed, those funds might be subject to repayment, but only if they were intentionally squandered or destroyed. It can be difficult to prove that those funds were intentionally squandered or destroyed. So if you can prove it, then you want the court to order an unequal division of the property to account for the money that was squandered. Now, what about spending during the divorce? How can a person prevent their spouse from recklessly spending all of the money that you've accumulated now that the divorce action has been filed? Wisconsin law prevents spouses from transferring or disposing of marital assets during the divorce. And it is only allowed for necessities, business expenses, or legal fees. So the standard after the divorce filing is often referred to as the restraining provision. And their spouses are ordered to refrain from destroying, transferring, or disposing of marital funds without the consent of the other spouse, or if there's an order of the court that allows it. So if your spouse violates that, they can be held in contempt of court. Now, the exception is if it is done in the usual course of business in order to secure necessities and in order to pay reasonable costs and expenses of the action, and that can include attorney's fees. Pre- and post-divorce expenditures. Let's talk about that. So what do we do with these pre- and post-divorce expenditures? If there is a dispute as to what was spent, it can be discoverable. You might need to bring in a forensic expert to look at the spending. Now that process could be expensive both in legal costs and expert witness fees. So really what you want to do is try to prevent marital waste. How do you do that? If you suspect your spouse is about to start recklessly spending, one of the best things that you can do is file a motion for a temporary order early in your divorce case. Now, a temporary order is effective because it can restrict spending on non-essential items. It requires both spouses to get approval before making large financial moves. It can help to ensure that joint funds are used only for agreed upon expenses. And if you don't act fast, you could find that your assets are gone, they're spent down, and in some cases they could not be recoverable at all. Can you get your money back is a common question. So let's say your spouse already wasted a large amount of money before the divorce. Can you get it back? A lot of people come and ask me that question. And in Wisconsin, courts can order essentially an unequal division of property at the end of the case if one spouse intentionally wasted those marital assets. So keep that in mind. However, proving that intentional waste, as we've talked about, can be a challenge. So the courts will consider whether the spending was reckless and if it directly harmed the marital estate. So let's run through some examples here for you. Let's say a spouse has drained the joint checking account and they use the money for gambling. That is probably waste and recoverable. What about a spouse moving money into a separate investment account? Well, that's really going to depend on whether the move was done secretly and whether it benefited both spouses. What if a spouse is spending money on vacations or luxury items? Again, that's going to depend on if the spending was consistent with how the couple normally lived. In that event, it might not be considered waste, but it could be under the circumstances. Most importantly, keep an eye on it. I want to talk next about financial fraud, what to watch for. One of the biggest areas where financial fraud happens in divorce is with closely held businesses. If your spouse owns a business, you might be dealing with more than just the question of how much the business is worth. There's also the question of whether they're using the business to hide assets or to manipulate financial statements in order to reduce the amount of money that they will have to split with you in the divorce. So before you hire a forensic investigator to come in and sift through the entire business, consider the cost of that, and it is very time consuming, so you need to be strategic about it. The things to look for in considering this are the red flags that could make you suspicious. One of those red flags is a sudden drop in business profits. So if this business that was thriving suddenly starts reporting lower profits right when the marriage is falling apart, that is suspicious. Of course, now businesses do go through ups and downs. Maybe they lost a key client, maybe the market shifted, or we suffered from a pandemic. But if the explanations seem vague or the timing feels a little bit too convenient, it is time for you to dig deeper. A business owner should be able to provide meaningful explanations to substantiate the reasoning for the decreased profitability and their numbers. But when the downturn coincides with problems in the marriage, that's when further scrutiny of the explanations should be considered. As our former president, Ronald Reagan, once said, trust but verify. So number 2 is, does your spouse have control over financial information? If your spouse is the person running the business and they refuse to share financial details, that is a big red flag. It's normal for business owners to be protective of their records, but in a marriage, both spouses should have at least a basic knowledge of the finances, especially when marital assets are at stake. Information and knowledge are very powerful, and while it's generally good practice to keep those financial affairs guarded by a business owner, again, any business owner should be given access to and be able to make inquiries about their own company's financial records and share them with you. Now, if they're being secretive about that, it could be because they are hiding something. So you want to look into owner distributions in partnerships, LLCs, and S corporations. Equity distributions that are made to owners are not typically reported as taxable income on a couple's individual income tax return. And that can be confusing, so hire an accountant to help you as well. Since these distributions are not reported as taxable income, they can sometimes be overlooked as a source of income in the divorce action. Now, the equity distributions are, however, presented on an owner's Schedule K-1, which are issued by the company, so get the K-1. Those equity distributions should be traced to your deposit accounts, your personal bank accounts that you have with your spouse. And if those distributions from the company do not match the personal deposits, that could be an indication that those assets are being concealed from you. Here's the third red flag. Mysterious loans and business expenses. Have you noticed any unusual loans in the business records? Maybe your spouse is claiming to you that the company had to loan money to a friend, which would be weird, or take out a new business loan for a reason that doesn't quite add up. Those tactics can be used to temporarily move money, so it looks like there are fewer assets available for division in the marital estate. Now, most people will focus how to measure a business based on the financial performance on just the income statement, but that's not really correct. The income statement presents the net profitability of the company, but it does not tell you the whole story. And a thorough review of a company's balance sheet can help you uncover fraud and abuse and get to these distributions. So a company's balance sheet includes amounts due to the company from other people and what the company might owe to somebody else. And if an owner decided to loan money from the business to a friend, that transaction would never appear on the company's income statement, right? So you got to get the other records. Now, a review of the balance sheet would reveal that money was loaned from the business for personal reasons, and you need to discover that. Number 4 to watch out for, business credit cards used for personal expenses, red flag. It's a sneaky one. Now, if your spouse has access to a business credit card, they could be using that for personal expenses, personal purchases, things like meals and travel, and they record that as a business expense. And when a business issues a payment, there's typically an accompanied detailed invoice that lists the product or service being purchased. And you should be able to use the invoices to determine the nature of the payment to determine if it was personal or for business. Now, credit card statements generally only indicate the date of purchase, the vendor's name, and the payment amount. That detail creates an opportunity, right, for potential abuse. So access to the business credit cards could provide the owner the ability to make personal expenditures under the premise of it being for business purposes. And that type of activity could result not only in hidden marital assets, but also a lower business valuation. And that can overall reduce a business's reported profits, make it look like there's less money available for support or property division. And if your spouse is running a business, their credit card statement should be carefully reviewed and should have detailed receipts to back up the expenses. Here's the 5th red flag. It's sloppy or missing business records. So if your spouse has business financials and they're just a mess, it might not just be poor bookkeeping, it could actually be intentional. And if the financial statements are not regularly reconciled or reviewed by an outside accountant, that could be a major red flag because now you're just relying on the owner. So let's talk about things on the legal side. What can you do? What if you suspect that your spouse is actually hiding these assets? Any one of the red flags we discussed apply to you. If they do, you may want to consult a forensic accountant or a certified fraud examiner. They're known as a CFE. These professionals specialize in tracking hidden money and they uncover suspicious financial activity. Now, in many divorces, emotions are running high, trust is already broken. It's natural to be suspicious, but it's important to make sure you have evidence before you launch this costly investigation. So ask questions, right? Watch for the warning signs, and if they exist, you do want to take action early rather than just letting these assets disappear. So raise your concerns with your lawyer, with your spouse, with the judge. Remember that judges are fact finders. They make decisions that are based on the facts that are known to them. Make sure you're telling the lawyers and the judge about your concerns so that your spouse can be questioned about the concerns. Start there. The lawyers or the judge may require your spouse to then produce the information that you're seeking to prove your concerns. And you can verify them or not. So the final thought that I have for you is to protect yourself. Don't trust anyone but yourself. And if you're going through a divorce, anticipating potential problems is key. Measure backwards from what you know from past behavior. And the best way to prevent that financial manipulation is to take action before the assets are gone. If you suspect financial fraud, work with your attorney, conduct discovery, request financial records, and if necessary, bring in those experts to trace the hidden funds. Divorces are hard, they can be financially draining, but you don't have to go through it blind. Stay informed, stay vigilant, and don't be afraid to fight for what's fair. If you found this video helpful, don't forget to like, subscribe, and hit that notification bell so you don't miss any of our future videos. And if you have any questions, drop them in the comments. We'd love to hear from you. Thank you for watching, and have a great day.